Next is when Ashley got to the hospital, she heard one of the medical personnel talking about a CAT scan, doing a CAT scan on her because she was pregnant. And Mr. Brockler agreed that this is hearsay and that it should be excluded. And even if he hadn't agreed, I would have sustained this objection. This clearly is hearsay, and so it is inadmissible. But I appreciate the people being candid. Next is at the hospital, Ashley Moser asked her mother about Veronica's status. And her mother apparently told her that they were taking care of her. That's hearsay. I can't remember now if the people agreed that that's hearsay, but it is hearsay and it's inadmissible, so that's not coming in.
Forgive me, Your Honor. One of the things I failed to do was add in the fact yesterday that at the time that the mother, I believe, tells Miss Moser Sullivan that it's not true. Veronica has already died, but they are sort of misleading, I think, Ashley to, I guess, keep her mind off of that and to focus on whatever treatment she has. So to that extent, it wouldn't be offered for the truth of the matter asserted. And I failed to tell the court that yesterday.
All right, I appreciate that. It's not particularly relevant, though. I don't know what the probative value is. What's probative is that at some point she found out that Veronica did not survive. That's what's relevant. I don't think, I think that conversation with her mother and her mother trying to keep this information away from Ashley Moser, while understandable, doesn't have any particular probative value here. So I will keep that out under Rule 401 and Rule 403. So to the extent that it has any probative value, I find that the risk for unfair prejudice is large enough that it gives me concern, and I will not admit it under Rule 403. But I will allow the people to elicit testimony that at some point she found out that Veronica did not survive. And in fact, if you want to ask, at some point Sunday, I think it was, did you find out that Veronica did not survive? I think that's an appropriate question. And it should be phrased in that fashion. Did she at some point find out that Veronica did not survive? And to the extent that there is a 401 objection to that, the objection is overruled. And same thing with a 403 objection. First of all, the jury already knows about this. So I don't know what prejudice there is. They know that Veronica Moser Sullivan did not survive. And I think it's probative to allow Ashley Moser, I think it's appropriate, I should say, to allow Ashley Moser to say when she found out that her daughter didn't survive. But it's a one-question proposition. In terms of the hearsay objection, I suppose technically it's hearsay, but there's no other way that people can get that information that at some point she became aware that her daughter is no longer alive. I think she has to be able to testify about that without going into a particular statement that was made to her. So this is based on her awareness that her daughter is not alive. And I think she can testify about that. Next is, Ashley was told at the hospital that she lost her unborn baby. Same type of thing. I think it's technically, I suppose it's hearsay, but the question should be phrased in terms of, at some point, did you find out that you had lost your unborn baby or that you lost your pregnancy? I think that's appropriate. This is her body. Of course, at some point, she became aware that her unborn baby was no longer alive, just as at some point she realized that her daughter Veronica was no longer alive. Whether anyone had told her that or not, she still at some point would have found that out. She still would have realized that. She would have become aware of it. So I'm going to overrule the hearsay objection on that. It has some probative value because this is part of the injuries that she suffered in this case, and the probative value is not substantially outweighed by the risk of unfair prejudice for all the reasons I stated in the record that I made a month ago, or maybe longer, when I admitted the loss of her pregnancy as evidence of her injuries in this case. So it is admissible under Rule 403.